Your Lordship, this civil revision is preferred against the order dated 2nd July 2025, passed by the learned civil judge in RCSA 74/2022. Your Lordship, that application was only partly allowed, and that's our objection. The subject matter in brief, Your Lordship, is that I'm the defendant number 2 in that civil suit, and defendant number 1 and the plaintiff are both related to each other. The plaintiff is the sister-in-law of the defendant number 2. So, Your Lordship, what had happened is that I'm the registered, I'm the buyer of this property, and I bought this property on 12th of November 2010. Now, unbeknownst to me, Your Lordship, next year,
You are plaintiff or a defendant?
I'm the defendant number 2.
Defendant number 2.
Yes, and I preferred the
You preferred an application.
Yes, Your Lordship. Yes, Your Lordship.
D.
Yes, Your Lordship.
Suit is barred by some law.
No, Lordship. It was the fact that the meaningful reading of the plaint will not lead to any suit being coming out of it, because
no cause of action.
No cause of action, Your Lordship.
No
because
cause of action.
Yes, Your Lordship.
Then what happened?
So Your Lordship, after I purchased this property, unbeknownst to me, on the 12th of April 2011, the Tehsildar passed an order executing the will of a living person. So this living person was defendant number 1. He was living at the time, and he also deposed. He also gave a testimony. And this is apparent from the order of the Tehsildar. This Tehsildar order, Your Lordship, was then overturned by the SDM court in 2022, on 5th of May 2022. And this again was upheld by the Additional Commissioner Court in April 2023. Now, Your Lordship, the Bhabi Devat duo is now trying to linger on the matter over and over again by filing this suit. In the last hearings, Your Lordship, I was ordered by this honorable court to get the copy of the plaint and my application for the
Your best.
Your Lordship, I'm the petitioner appearing in person.
In person.
Yes, Your Lordship. So I was also required to bring the copy of my application under order 7 rule 11. So, Your Lordship, I'd like to humbly direct your attention to the additional documents that have been filed, which is the plaint of.
First of all, read your impugned order. What was the order? What is the application? See this, see that. There is no meaning in hearing these all kind of arguments without the order which is there.
Yes, Your Lordship, the order. Yes, Your Lordship, the order is P4. And if I may read.
What is the application? उक्त आवेदन अंतर्गत 7 नियम 11 सीपी सेक्शन इस प्रकार है कि वादी को प्रकरण में वादी के वाद में हेतु प्रकट नहीं होता है। प्रतिवादी में वादी के पक्ष में दिनांक 21/9/2000 को वसीयत होना बताया है, किंतु वसीयत प्रतिवादी का एक वादी के पक्ष में दिनांक वसीयत होना बताया, किंतु वसीयतकर्ता की मृत्यु के पूर्व ही वाद प्रस्तुत किया गया। प्रतिवादी क्रमांक 1 जीवित है तथा दिनांक 30/8/22 को खराब प्रस्तुत किया गया था, उसके विरुद्ध एक उचित कार्रवाई हो चुकी है। तो कोर्ट फी आपका वैल्यूएशन और कोर्ट फीस का तो मान लिया।
Yes, sir, मान लिया। पर sir, I'd just like to request your attention on the plaint that I was required to file in the last hearing. So, Your Lordship, if I may read from the plaint.
हाँ, एप्लीकेशन के साथ लगा है।
Yes, Your Lordship, it's 7711/2025. It's number 11.
Sir, first time in this case, amendment application is filed also.
Yes, Your Lordship, it was also amendment application.
ये 617 लगाई है, 617 के साथ लगा है डॉक्यूमेंट।
No, Your Lordship, I filed 617. That is some separate documents that are needed because I was ordered to get the plaint. So the plaint has been brought on record, Your Lordship. And sir, 61 number page. And in that,
वो application के साथ लगा है।
Sir, I made two filings. That's as I was. Yes. So I was supposed to file 2 documents as per the court's order, and then I also preferred an amendment in the records. So, Your Lordship, on page number 4 in the IF 7711/2025, I am reading from the 4th point. यह प्रकरण इस प्रकार है कि sir, what I like to highlight is the loosely worded argument that the plaintiff is making. यह प्रकरण इस प्रकार से है कि वादी के पक्ष में प्रतिवादी ए के द्वारा वचन पत्र वास्ते बेचनामा दिनांक 2/7/9 को खसरा नंबर 132 कुल रकबा 0.51 हेक्टेयर जमीन जो कि ग्राम छिवला पंचायत तिलहरी जिला जबलपुर में की स्थित भूमि का वचन पत्र लिखा था एवं इसके पूर्व 5/1/98 को लिखा था एवं कब्जा दाखिल वादी के पक्ष में प्रतिवादी एक द्वारा स्वेच्छा पूर्वक दिया गया था, जिससे जब से वादी उक्त वाद संपत्ति पर काबिज है, जिसके पश्चात जिसके पश्चात वादी ने न्यायालय तहसीलदार जबलपुर में प्रकरण क्रमांक 270/6/2009-10 प्रस्तुत किया, जिसमें 25/4/2011 को वादी के पक्ष में मध्य प्रदेश शासन के नामांतरण हुआ. Sir, a bare reading of the Tehsildar's order, which is now been brought by me in the amendment of record, shows that the Tehsildar order was only passed based on the Wasiyatnama. The purported Bechnama. First of all, Your Lordship, under transfer of property right, they cannot be affecting the property transfer by just an unregistered, so to say, Bechnama, which has yet not been presented by the plaintiff and throughout the suit. And every time they get an opportunity to produce their evidence, they keep on seeking time and time over again. Now, this, Your Lordship, this argument was never brought before the revenue courts, even at the SDM courts or at the collector or at the commissioner's court. But now they have come up with this statement that we had a base, so to say, Bechnama, and now they are claiming that based on this Bechnama, the Namantan Adesh was passed, which is a total act of perjury, Your Lordship, and is utter falsehood. If I may request your Lordship's kind attention to the amendment in pleading of records, the order of the Tehsildar, and I am reading, Your Lordship. आवेदिका श्रीमती दसुदा बाई चौधरी, पति राजकुमार चौधरी, निवासी 1119 ग्वारीघाट, थाना गोरखपुर जबलपुर ने इस न्यायालय ग्राम छेवला नंबर 28 स्थित भूमि 132 रकबा 0.51 हेक्टेयर की भूमि पर वसीयतनामे के आधार पर स्वयं के नाम पर दर्ज किए जाने हेतु पंचसाला खसरा वसीयतनामा एवं शपथ पत्र की छाया प्रति सहित न्यायालय में आवेदन प्रस्तुत किया है. नाउ इन द सेम ऑर्डर, योर लॉर्डशिप, इन द सेकंड पेज, पॉइंट नंबर 8, नामांतरण की अनुशासन की जाती है. पटवारी प्रतिवेदन प्रदर्श 1 है. वसीयतकर्ता श्री तीरथ प्रसाद को आहूत किया गया एवं उसके बयान भी लिए गए, जिसमें उसके द्वारा बताया गया कि ग्राम छेवला फलाना
property belongs to whom?
Your Lordship, it belongs to me. I am the registered owner. I have purchased through registered sale date, which is annexure P1. But unfortunately, Your Lordship, by unbeknownst to me, they had got the Namantan executed based on the bill of
in which year?
in 2011, Your Lordship, which was then overturned by the SDM court, and then SDM court also ordered that Namantan be made in my favor. Then again, it was challenged by the plaintiff, the Sudabai, and the additional commissioner's court again upheld the order because it is patently illegal. How can the will of a living person be executed?
Then what happened? Your name has been mutated.
Pardon me, Your Lordship.
Then your name has been mutated.
No, Your Lordship. Parallelly, they started the civil suit, and every time I go to the SDM court, they say.
But when their order for mutation has been set aside by the SDO.
Yes, Your Lordship.
Then whose name has been recorded now?
It's her name only. It's still in the record. My application for
execute that order.
My application for Namantan has already been rejected, and now it's been challenged in a separate WP, Your Lordship.
No, so why it has been rejected?
Your Lordship, ironically, it's just based on a Patwari's.
Mutation order has also been set aside.
Pardon me, Your Lordship.
Their mutation order has already been set aside.
It has been set aside by the additional commissioner's court, but the land revenue record has not been amended with that effect. I was supposed to.
Application.
Yes, I moved the application. That got rejected.
Application with the registry.
With the Tehsildar.
Revenue records.
Yes, Your Lordship, he rejected my application. And he rejected my application based on a frivolous doubt that because it's been 11 years that this has happened, that happens to be a total contempt of the court. That's why there's a writ petition being preferred.
That gives you a different cause of action.
Yes, Your Lordship. Which has been preferred, Your Lordship. And that's why I'm not discussing that case over with you. But Your Lordship, what I'm trying to, the case that I'm trying to make is that, through natural justice, Your Lordship, if leniency is being given to the guilty, then it's cruelty to the innocent. And I have got the registered document. They do not have any Bechnama. The Bechnama that they have not even produced a single copy of the Bechnama.
They will be non-suicide.
Yes, Your Lordship, but
not at the stage of 7-11, because once they have taken some pleading, that they are.
Your Lordship, but I'm also basing my argument on.
If they are basing their rights on some document, and they are not, if it is not produced, then they will be non-suited.
Yes, Your Lordship, and they are, the point here, sir, remains that they are taking advantage of the fact that Namantan is in their name. They are prolonging the case.
Or that to have a remedy in the revenue law.
Yes,
which
I have preferred that.
Their mutation has already been dismissed by the higher courts.
Unfortunately, Your Lordship,
now get that executed.
Your Lordship, if they are committing an act of perjury and they are being allowed to keep their matter going against me and keeping the property as
keep
disputed.
The matters different. This is talk. We are discussing right now 7 Rule 11.
Yes,
so
Your
keep
Lordship.
your argument to the extent of 7 Rule 11.
Yes, Your Lordship. So
now what is happening in revenue? Why you are not executing it?
That's why I did. Your Lordship,
what they have done, that is entirely different.
With all due respect,
file a petition against that.
Yes, Your Lordship. That's why I did not bring that matter up over here. All I'm trying to say here,
you just confine your arguments to the extent that
Yes.
whether from bare perusal of the complaint,
Yes,
whether suit can be thrown out under
Yes.
order 7-11.
yes, your lordship, because
Show me that.
sir. So, sir, in the plaint that they have already
If
said,
they don't file that benchnama or whatever it may be, they will be non-suited.
your lordship, but that is going to take a substantial amount of time. I am
So
already been
that
ousted
cannot be
from-
curtailed. That is CPC. It
I
cannot be curtailed.
But
By
your
the
lordship-
High Court under 7-11.
but your lord,
Can it be?
because your lordship, this is
If somebody says that I am the owner on the basis of some document and he doesn't file that document, what will happen? He will be non-suited.
but sir,
Now you say that it is to be done today itself on 7-11. Then where is the question of that?
your lordship, justice delayed is also justice denied, your lordship. It's just gonna keep on delaying. They keep on coming and
This
taking
is
dates.
put to hear, but not in practical sense.
I with
Our
all-
procedure are like that it takes time.
but your lordship, they are abusing.
Can we
this.
shorten it?
My humble request is, your lordship,
That can be shortened by your active participation in the suit. Go file application every day. Decide it.
now your lordship, the stage of the civil suit is that now I have to go get the mulyankan of the property. They value the whole property as 26,000 rupees, which the
The court
circular
has
is
said
18
that
lakhs.
your application party allowed. The court has said that they have to value the suit as per the valuation.
But your lordship, the Supreme Court in various judgments has expounded upon the powers of the 7-11. So one of which is Subdet Sabil versus Assistant Charity. And your lordship, in page number 5, I can supply you the copy, your lordship. It's been said that the trial court must remember that if a meaningful and not formal reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue. It should exercise the power under 7 order rules 7 rule 11. Moreover, it also goes on to say, your lordship, the real objective of order 7 rule 11 is to keep the court keep out of court the irresponsible lawsuits. Your lordship, this is totally irresponsible lawsuit. That's only my contention.
You want order on merits or you want to withdraw and should I give the direction to the trial court to decide it expeditiously?
Yes, your lordship, that would be preferred.
Petitioner has, after arguing some time, has prayed for withdrawal of the petition with liberty to raise the issue at an appropriate stage. With the aforesaid liberty, the petition is dismissed as withdrawn. कितने साल से पेंडिंग है?
So it's 2022 का है, and it's been pending since then. And also, sir, there's a MP case flow management rule that says that within 24 months such suits have to be decided. It's also going against that. Your lordship, I humbly request that.
And also pray the direction we issue to the court to decide the suit expedition. The net court below is expected to decide suit as early as possible.